Mute myself until it's time.
Good afternoon, everyone, and thanks for joining us for this panel today, where we're going to discuss the 11th Circuit Year in Review, the criminal docket. I first want to thank our host, the American Constitution Society. ACS is the country's foremost progressive legal organization with over 250 student and lawyer chapters nationwide. The ACS is comprised of progressive lawyers, law students, judges, scholars, advocates, elected officials, and many more working together to advance laws and legal systems that protect and improve the lives of all people. I now want to introduce our all-star panel. First up is Judge Kathleen Williams. In 2010, President Obama nominated Judge Williams for a position on the United States District Court here in the Southern District of Florida, where she has served since her Senate confirmation. Tamara Lawson is Dean and Professor of Law at St. Thomas University. She previously served as the law school's Associate Dean for Faculty Development and Associate Dean for Academic Affairs. Emily Smichetti is the former longtime appellate chief and current Executive Assistant United States Attorney at the Southern District of Florida, U.S. Attorney's Office. Andy Adler is a superstar appellate lawyer at the Federal Public Defender's Office. I am, of course, unbiased. We want to thank Andy, who has taken time out of his prep work for his Supreme Court argument next month. I would also be remiss if I didn't state how wonderful I think both Emily and our appellate divisions are. Bernardo Lopez is the chief of the appellate division at the Federal Public Defender's Office, and Lisa Rubio is the chief of appeals at the United States Attorney's Office. Both Bernardo and Lisa are terrific lawyers, but more importantly, terrific people. Before we get to the cases we're going to discuss today, I did want to note that there has been a significant change in the court's membership. Judge Beverly Martin has left the court, and she figures prominently in at least two of the cases we're going to discuss today. And President Biden recently nominated Nancy Abudu from the Southern Poverty Law Center to join the court. She's currently awaiting her Senate judiciary hearing. We're going to discuss three cases today. I'm first going to try to briefly summarize the case for you all, and then I'm going to ask the panelists a number of questions about those cases. So first up is United States versus Campbell, a decision by the en banc 11th Circuit only rendered a couple of weeks ago. In Campbell, the court considered whether the good faith exception to the exclusionary rule is a proper ground for affirming Campbell's conviction despite the government's failure to raise that ground before the panel. The majority answered yes. The en banc court also concluded that the good faith exception applied and affirmed the denial of Mr. Campbell's motion to suppress. In the district court, the judge found that the police officers had reasonable suspicion to stop Mr. Campbell's car on account of his rapidly blinking turn signal, and that the officers did not unreasonably prolong the stop by asking Mr. Campbell 25 seconds worth of questions unrelated to the purpose of the stop. Because the district court found the seizure reasonable, it did not address whether the good faith exception to the exclusionary rule applied. On appeal, Mr. Campbell once again challenged his seizure, and a panel of the court affirmed. In affirming, however, the panel considered the good faith exception, which, though fully briefed in the district court, was not addressed by the government on appeal. The court then granted Mr. Campbell's petition for rehearing and asked the parties to the en banc court to focus on whether the court could rely on the good faith doctrine. In resolving the case, the en banc majority held that the court may exercise its discretion to consider the good faith exception despite the government's failure to brief that exception to the panel. The court treated the government's failure to raise good faith on appeal as forfeiture and not a waiver. The court held, therefore, that the issue may be raised by the court sua sponte in extraordinary circumstances after finding that one of the forfeiture exceptions apply. The en banc majority did so in light of the government's acknowledgement at oral argument that it was conscious of the good faith exception when briefing the panel. In this case, the en banc majority found that the fourth exception to the forfeiture rule, where the proper resolution of the issue is beyond any doubt, applied. The en banc majority also found that the case presented an extraordinary circumstance to justify the court's exercise of its discretion to excuse the government's forfeiture for a number of reasons, primarily because of the strong policy considerations underlying the exclusionary rule. Turning to the merits, like I said, the en banc majority held that the officers acted in good faith. Judges Newsom, Jordan, Wilson, Rosenbaum, and Jill Pryor dissented. They viewed this case as one about judicial power and its limits. The question presented in their eyes was, can an appellate court affirm a criminal defendant's conviction on a ground that, although argued to the district court, the government concedes it consciously decided not to present on appeal? The dissent answered that question no, relying on the principle of party presentation and the critical distinction between waiver and forfeiture. Okay, sorry for that long explanation, but there was a lot to unpack in the case. So as most all of the judges stated, this opinion seems to be about judicial power. In his concurrence, Chief Judge Pryor framed the issue this way. This appeal concerns when the judicial branch should intervene on behalf of a criminal to exclude indisputably reliable evidence. Now, to me, the opposite seemed true, that the court actually intervened on behalf of the government to raise an issue that the prosecutor had abandoned. I'll direct this question to Dean Lawson and ask, where do you stand on that debate?
Thank you for the question. You know, this case is so rich in various ways of how this issue is being parsed. And when we look at the exclusionary rule, you know, we're looking at when the court must exclude evidence, and we're talking about real, not planted, relevant and reliable evidence. So I do think it is appropriate for the court to use all the tools in its legal toolbox to preserve the exclusion of evidence to those cases where it's absolutely necessary. And we've seen in the jurisprudence that the deterrence rationale is the real rationale that prevails. But this case is about just as much about what the court does talk about as it is about what the court does not talk about. And what I thought was noticeably not talked about in this case was the fact that the defendant was weaving when the officer originally observed this traffic violation. And nothing in the police investigation went toward finding out why the suspect was weaving. It was all about the taillight and whether, you know, a detailed discussion of whether the rapid blinking of the taillight is it working or is it not working? Does it violate the statute? Does it conform to the statute? And nothing in the investigation about, well, could weaving have been you're too tired, you're drunk, you're impaired, you're using your cell phone. So I think this case is as absent in a discussion of pretext and what was the real motivation of why this suspect was even stopped in the first place, and whether the analysis of reasonable suspicion goes a little sooner in the analysis as to the stop. And it leaves us thinking, which is the common argument sometimes about the exclusionary rule, have the exceptions, including the good faith exception, really swallowed up the rule, and we need a deeper analysis or additional tool in the toolbox to make sure there's real deterrence or real enforcement of our protection under the Fourth Amendment.
Thank you, Dean. I'm going to direct my next question to Judge Williams. Judge, because as both opinions acknowledge, judges do rely on the parties to present and frame the issues for the court, how do you address relevant issues that the parties have not raised? So for example, if, as Chief Justice Roberts says, judges are just there to call balls and strikes, this case seems to be more that the umpire was telling the pitcher to throw his fastball rather than his curve. So how do you handle these issues in the district court? And does your approach differ if one of the parties is pro se?
Well, I have to concur with Dean Lawson about the richness of this opinion. There's a lot to unpack in terms of not only the issues, but some of the language used by the judges on both sides of the decision. You speak of Justice Roberts. I was intrigued by the discussion of the passivity and the modesty of the trial court. I don't know that we'd get a lot done being wholly passive, but I understand it to mean that courts do not, nor do litigants want any type of issue creation by judges in a case. Now, having said that, if the parties do not brief me on a matter, if they do not emphasize the facts or the law as to a certain issue, unless there is an 11th Circuit or Supreme Court decision squarely on all fours, I think I need to trust the party's analysis of what I am being asked to determine, and I do. As I said, if there is a matter that has been pending in the Supreme Court, or a request for certiorari, or something that the 11th Circuit decided, say last week, which I would raise, I trust the parties to fully develop their case for me. Now, as to pro se litigants, of course, the law is that courts should be liberal in construing matters brought before it by a pro se litigant. So if you can find an issue that may not be articulate, but it is evident from a reading of what has been submitted to you, I think you accept it, or you ask a pro se litigant to amend. But the interesting dynamic, or perhaps not dynamic, perhaps it's a juxtaposition or just a point of discussion, is the procedural default that is a part of many of the pro se litigation and matters brought before courts, in that those standards seem to be extremely rigid in terms of what has been briefed, articulated, brought before courts, certainly in the Johnson context and others, for pro se or defendants, not the type of indulgence or latitude that seems to be engaged in here, although I think the majority rightly discusses the fact that this is not a matter that was wholly abandoned, as it were. I know I'm not using the forfeiture waiver dichotomy appropriately.
Judge Joe Fly will be very upset with you.
Well, it certainly wouldn't be the first time, but I just, it's an interesting review of language, I think, and analytic paradigm when you have a situation such as was presented in Campbell, and then when you have some of the situations pro se litigants present for relief.
Thank you, Judge. The next question I'm going to pose to Emily. In this case, there seems to have been a conscious decision by the government not to raise the good faith argument on appeal. To me, that seems to be an unusual decision, although the only context I have is litigating against your office, where you never seem to miss arguments A, B, C, or D. But as an appellate lawyer for the government, can you discuss what ordinarily goes into the decisions as to what issues to raise and how to frame them for the court?
Sure. I mean, I think that the default for the people in my office and certainly in your office is to sort of raise all the available arguments that you have to affirm the conviction based on anything that you have in the record. I think this is a little bit atypical. I sort of carefully listened to the oral argument to see what the language was. And I think the panel stage briefer here was certainly aware that good faith had been something brewing in district court. And I think the word was she had unwarranted overconfidence in her merits argument. And so I think it was consciously omitted, but perhaps not strategically. And what I mean by that is, I don't think it was a case where the panel stage briefer was trying to force a decision on the merits and waive. I think it was just sort of a missed argument. So, what we do is we look at how much space we have available in our brief, and we try to at least make a footnote or make some reference to every argument that we have available. Have I made a mistake on that? For sure. And I think that, you do your best. And I've definitely had I remember one case, a stay at oral argument, where it was just not, and I think this was a focus somewhat of the oral argument, that no one had really framed it in terms of good faith. And that's no disrespect to any party. It just wasn't really the focus. And sometimes when the whole focus is on something else, you just make that your focus. And that's just a skill you develop as a lawyer. So I think, sometimes a judge might say, well, does anyone even really have standing, or come up with something? Troflat is very good at that, out of ether, and no one's really thought of it, and we've had to write letters after the fact or whatever. So I think the best practice is to always make all of the arguments that you can, and that's what we try to do. But no one is perfect, so which led us to Campbell.
For sure, no one is perfect. So the next question is for Andy, although I'll give Emily time for rebuttal if she wants. So Andy, this case turns on the majority's conclusion that the government forfeited the good faith argument rather than waiving that argument. Who do you think has the better of that view, the majority of their dissent? That is what is called a softball.
Thank you. I appreciate softballs always. So I agree with the dissent here that this was a waiver rather than a forfeiture, but I think we're going to talk about the oral argument exchange a little bit, but I actually think it was a waiver without regard to the oral argument exchange at all, because, this is a situation where the district court is telling the government to brief an issue, to brief the good faith issue. And they do, and they brief it. And then it comes up on appeal and they don't raise it. And that situation to me is an intentional relinquishment of the issue. It is aware that the good faith issue is there, and it decides for whatever reason, strategic or not, to leave it on the table. And so to me, that just strikes me more as a waiver than a forfeiture, which I understand to be just the mere failure to raise something without, inadvertently, without realizing that the issue is in play. And, there's a case by the Supreme Court, Wood versus Milliard, which is discussed by both the majority and the dissent. And I think the import almost gets lost a little bit, because in that situation, what happened is it was a habeas case, and the state came in and said, in the district court, said, there may be a statute of limitations defense here. We're not conceding that this is timely, but we are just not going to raise that issue. And the Supreme Court said, well, the state was clearly aware of that issue and decided not to raise it. So that's a waiver. And it's hard for me to really see any meaningful distinction between that and this case. But what I think the majority is doing, and this may be one of the biggest implications of this decision to me, is it has a really narrow conception of waiver. And I think it's limiting waiver to situations where a party is unequivocally, affirmatively in writing saying, we waive this issue. And that's just not going to happen very often. And everything else is going to be a forfeiture. And it seems to me that the majority is doing that deliberately so that it can preserve as much discretion for itself, the court, moving forward to resolve cases sua sponte, to raise issues sua sponte, where the parties just don't frame it the right way, or they miss an issue, which can happen. And so I understand the court's perspective in wanting to broaden forfeiture and narrow waiver. I have a different perspective on that, but anyway, long story short, I think this was a waiver.
Thank you. Emily, do you disagree with Andy's well-reasoned analysis?
I mean, I'm sort of, it's my job to disagree with Andy. I mean, I understand Andy's point. And I think, one thing worth pointing out about Campbell is it's a pretty narrow area of disagreement, right? So everyone agrees that if you affirmatively waive an issue, it's sort of off the table. And then where we are is in this gray area where, it's either omitted or sort of for whatever reason, right? And so, it sort of seems to me that Campbell's kind of equal opportunity, so that the failure to raise an issue in an initial set of briefs is, theoretically the court could reach out and make, take on any issue that it wants. Both, I mean, I know that the response will be that that's more often in the case of the government who's seeking affirmance of a conviction, but and I would just say that the government does sometimes, I mean, I think in particular, Andy and I had many Johnson cases where we would say, we are not relying on, we do not want the court to go here and rely on this issue, or in habeas, sometimes we do that. And so I think that now that we have these parameters, that when the government is waiving something, we will try to be as clear as possible about that, so that there's no, and P.S. the court can still always disagree with us, which we know happens in certain other cases that we'll probably discuss later, but that would be my take on that.
Great. Well, thank you. And I'm going to direct the next question to both of you as well, because this concerns, I think, as Judge Williams alluded to, what had occurred at oral argument. And this is very interesting to me, that the sort of like the internal strife in the court sort of spills out onto the page. So in the majority opinion, there's essentially an argument between the majority and the dissent about how the dissenting judges acted at oral argument. The majority accuses the dissenting judges of conducting an evidentiary hearing at the oral argument, in the sense that they were trying to get the government lawyer to concede or acknowledge or come forward with whether this was a conscious decision not to raise good faith. The majority describes the dissenters' questioning as antics, which strikes me as odd, and the dissent took issue with these strong words, as they called them, because in my view, and I certainly don't have as many oral arguments in front of the court as you two do, but the questions that were reproduced in the opinion seem to be fairly ordinary, tough questions you get from a majority of the judges on our court. So, Andy, if you want to go first as to whether these were indeed antics by the dissenting judges.
Sure. No, I don't think they were antics. I think the questions were totally proper, and I've been the recipient of very aggressive questioning by the author of the majority opinion. So I don't think he means it to say that the tone or anything like that was improper. I think what the majority is saying, and I actually think the majority is right about this, is that if you are really treating the lawyer at the podium as more as a witness than the lawyer, and you really do get close to making credibility determinations and appellate fact finding, which can be really a fraught endeavor. And in my view, I think I don't even know that it would be relevant to ask a lawyer at oral argument, did you waive this issue 5 years ago when you filed this brief? Because that to me is inviting a factual question. Because let's say the lawyer in this case stood up and said, and this is the lawyer in this actual case was candid, it seems, but you can imagine a situation where a lawyer stands up and says, I called the lawyer who wrote this brief 5 years ago, and they said that they just, happened to overlook that entire part of the record where the good faith issue came up. And so, it was totally inadvertent. Now, is the Court of Appeals required to credit that dubious assertion? I don't know. And if it does, is that a credibility determination that appellate courts really aren't supposed to make? So I think that is really the problem that the majority is identifying, not really the tone or, because obviously I think, everybody on the court was wondering what actually happened here, and it was perfectly reasonable for the judges to try and figure out what went on. But I certainly don't want judges to be making credibility determinations about my representations in oral argument. So maybe it's a little selfish on my part.
Do you have anything to add, Emily?
Yeah, I mean, I listened to the oral argument and I thought the tone of the questions was totally fine. It was actually a very pleasant and, collegial exchange. And I don't think the questions were surprising either, because obviously that's what I wanted to know listening to the argument, right? I wanted to know the answers to those questions. So those two things, I think the content is a little problematic. And, I think there's sort of an institutional interest in keeping our internal deliberations process where it belongs. And so in this case, and Judge Newsom even sort of gives a little nod to this, because he sort of says something to the effect of, this is a little bit unorthodox, this line of questioning, and it's like, I don't want you to tell me anything about any internal information, but also I want to know the answer. And so it's a little bit strange and probably not something to be encouraged, but I totally got it. And I certainly have had questions like that, as has Andy, and didn't find it particularly egregious in that way.
I think,
Yeah, I differ on that. When I get those type of questions, I find it is egregious that I have to answer the judge's questions. But anyway, Judge Williams, did you want to add something?
no, I was just saying, I think this, to use Andy's word, because it could be fraught, this underscores the importance of the court reviewing the record it has and the record that the parties have presented and the arguments they have presented. And again, I go back to I understand it's a different standard and a different context altogether, but how often in habeas and other analyses, the court has emphasized that the burden of proof and persuasion and the finality of decisions based on someone fulfilling that burden, and to go beyond those parameters, perhaps to inquire, as happened in OA, and is to make that whole area of jurisprudence, I suppose, a little murky, but it certainly hasn't inhibited review of records where a defendant or a defense attorney back in the day didn't bring up an argument because it had been settled in the 11th Circuit, and judges are unhappy that you bring these up and fill their record, and then lo and behold, some years later, you're told, well, you didn't preserve that. Okay.
I wanted to jump in and just say, to Andy's point, that it's also problematic if we were to allow, the court not to use all of the potential rationales, because then the court may not have gone into great detail about their view of the number of seconds being not the point for us to consider. We got a lot of clarity in the ruling from that section that the court may not have, been willing to give us if they also didn't have the exclusionary rule exception to affirm the ultimate decision.
That's an excellent point. Thank you, Dean. So the next case we're going to discuss is United States versus Bryant. Bryant was on appeal from the denial of a compassionate release motions that are near and dear to my heart. As part of the Sentencing Reform Act of 1984, Section 3582 authorized a court to reduce a term of imprisonment for extraordinary and compelling reasons. But the Sentencing Reform Act did not put district courts in charge of determining what would qualify. Instead, Congress directed the Sentencing Commission to define what should be considered extraordinary and compelling reasons. It took the commission over 20 years to publish its substantive definition of what constituted extraordinary and compelling reasons. But the commission's 20-year delay didn't really matter because Section 3582 allowed only the Bureau of Prisons to file these motions, and the Bureau of Prisons rarely did so. Because of widespread criticism, the commission in 2016 conducted an in-depth review and held a public hearing and revised the guidelines section at issue. It expanded, reorganized, and clarified Section 1B1.13 and clarified the 4 categories of extraordinary and compelling reasons: medical conditions, age, family circumstances, and other reasons not listed above. In 2018, 2 years later, Congress passed and the president signed the First Step Act. The First Step Act expanded who could file a motion for reduction of sentence. Now the defendant or his or her lawyer could file directly with the district court. Under the First Step Act, Section 3582 allows a sentence reduction only if such a reduction is consistent with applicable policy statements issued by the Sentencing Commission, one of those which must define extraordinary and compelling reasons. After the First Step Act was passed, Mr. Bryan filed a compassionate release motion arguing that his situation presented extraordinary and compelling reasons warranting a reduction. In support, he pointed to several facts. As of today, he would not be subject to a 25-year mandatory minimum. 2, he received a higher sentence than some of his co-conspirators because he chose to go to trial, the infamous trial penalty. And 3, he had a good record of rehabilitation in prison. In the district court, the government responded that none of those reasons, alone or in combination, met the Sentencing Commission's binding definition of extraordinary and compelling in 1B1.13, and the district court agreed. On appeal, the 11th Circuit affirmed. Breaking with the 7 other circuits to address the issue, the court held that the sentencing guideline remains an applicable policy statement and thus constrains courts considering a defendant-filed 3582 motion. Judge Martin dissented in a 20-page opinion, reasoning that the policy statement only applies to BOP-filed motions. Judge Martin also emphasized that the majority limited the inmate's ability to seek compassionate release, prevents courts from conducting independent and individualized consideration, and revised the problem that the First Step Act was meant to resolve by leaving the determination in BOP's control. I'll start again with Dean Lawson. Dean, before the First Step Act, a defendant was eligible for compassionate release only if the BOP director filed the motion. But of course, the Bureau of Prisons rarely file these motions on behalf of inmates. The First Step Act was meant to remedy that and make compassionate release more encompassing. As a policy matter, can you describe the benefits of authorizing district judges instead of the Bureau of Prison to grant a sentence reduction for extraordinary and compelling reasons?
Yes, thank you for that question. And I think that if we've learned anything in the recent years since 2020 of the pandemic, we've learned that there can be change in circumstances beyond your control. And so expanding the access to this type of motion is a positive thing from a policy standpoint, expanding it beyond just the director. And the Bureau of Prisons also may have different motivations or and competing interests behind when and in which cases they would even seek to pursue this type of motion. So for the reasons of access and expanded access of these issues, this is a very important advancement.
Thank you. Thank you, Dean. The next question I'll direct to Emily. Emily, at the time of the 11th Circuit's ruling, all 7 Court of Appeals to address this issue had held that the policy statement is not applicable to defendant file motions for the purposes of the First Step Act. I know you probably have limitations on what what you can say, but can you talk to us about how the government decides to pursue or not pursue arguments that conflict with the consensus view of the Court of Appeals?
Yeah, so, and I think actually we're up to like 9 circuits. I mean, I think almost everyone
Now,
disagrees
right.
with the 11th Circuit, which is the 11th Circuit's kind of signature move in many arenas. So, I mean, without getting into the sort of DOJ internal politics, I think that the DOJ does take it pretty seriously when a number of courts of appeals disagrees with its positions, and actually does flip positions. It seems to me often, because we're the people who are often like implementing the position change and explaining why we said one thing in district court and we're saying a different thing in appeal. And so recently, I think, and Terry's a great example, we flipped positions to the friendlier defense viewpoint in the Supreme Court. The Supreme Court appointed an amicus to brief our old position. He won. In another scenario, I think in the 404 litigation, we flipped on multiple object conspiracies recently. So I think that we do re-examine the position and we do look at it. I think what's going on here, if you look at the CERDOP in Bryant, is that it's a guideline issue, and the sort of the basic import of that is that the commission is going to fix 1B 1.13, and they're in the best position to do that, and anything that the court does is sort of going to be not the last word on the issue. And so I know that is unsatisfying because it's going to take a long time. And I think one thing Andy and I will agree on is that there's extreme frustration with no sentencing commission and no clarification on some of these issues. The Sentencing Commission has a big stack of work to do and isn't even, in the process of being constituted yet. So stay tuned. You never know. But that's where we are with Bryant right now. Kind of no position.
No, that's definitely an issue. As you say, we haven't had a fully functioning commission in quite a while. I think we were trending to getting one sooner rather than later. But then lo and behold, we have a vacancy on the United States Supreme Court. And for whatever reason, people seem to be very engaged with that process.
I think that's maybe a higher priority item right now, but hopefully we're thinking maybe spring, we'll get these commissioners working and promulgate.
As I often tell people, I do hope, but I often tell people, hope is not a strategy, but hopefully we have one by the end of the year. So as Andy, as Emily said, there was a cert petition in Bryant, which was denied. But in his cert petition, he argued that the 11th Circuit had engaged in a flawed, superficially textualist inquiry by focusing on dictionary definitions of the word applicable and then asking the wrong question. For instance, reasoning that applicable means capable of being applied, the court concluded that simply because some of the substantive standards within the policy statement could be applied by a district court, the policy statement was therefore applicable. Wow, that's a long sentence, and I give credit to anybody who could understand what I just said. But Andy, hopefully you did. What's your view as to the statutory interpretation engaged in by the 11th Circuit?
Yeah, so this is an interesting case study in textualism, because everyone is really purporting to do textualism. That is the dominant mode of statutory interpretation, and I don't see that changing anytime soon. But sometimes we see cases where you pick up the statute and it's really ambiguous and you don't know what the answer is, and you've got to break out the dictionaries and the canons and all the tools that we have and see how they shake out. In other cases, you just pick up the statute, you read it, and you get the answer. And I think this case was one of the latter cases where you just pick it up and you read it, and you see what the answer is. And I think the majority sort of overcomplicated what was a straightforward statutory question. And so in this case, you pick up the statute 3582, and it says, no compassionate release can be granted unless it's consistent with the applicable policy statements. Everyone agrees the policy statement here is 1B113. The very first sentence of 1B113 says, upon motion by the BOP director, relief can be granted for X, Y, or Z criteria. And then you go to the application note, and in the application note, note 4 says that relief under this policy statement can be granted only upon a motion by the BOP director. So that would seem to answer the question whether the policy statement applies to motions filed by someone other than the BOP director, like a defendant, prisoner. And the answer seems to be no. And, I think that's the flaw in the majority's reasoning, is it's not really, I don't think it has a great answer to that text that I just mentioned. I think what the majority is doing is dismissing that text as prefatory and as prologue and as non-operative. So what the majority, I think, is doing is making the policy statement applicable by sort of severing the language that I just mentioned. Because the majority seems to say that, well, if you look at the core of the policy statement, it lists the grounds for extraordinary and compelling reasons. And if you sort of take that out of context, those reasons can be made to apply to defense filed motions. Of course, to do that, you kind of have to ignore the surrounding text in the policy statement. So this is just one of those cases where I think, I'll credit the majority. I think it gave the best possible argument on the other side that has been or could be given. Ultimately, I don't find it to be persuasive, largely for the reasons of it's now 9 other circuits. They're all, I think, unanimous. So by my count, I think the breakdown is 28-2 in federal appellate judges, which is pretty overwhelming. And that's of judges of all different stripes too. I think Judge Easterbrook wrote for the 7th Circuit, Judge Oldham in the 5th Circuit. And, just to circle back to the last question that Emily was raising, if you look at the Solicitor General's response to the cert petition, I found it very unusual because they said nothing about the merits. And usually in those briefs in opposition, they lead with the 11th Circuit was right. And they just don't say that. So I thought it was another telltale sign that, yeah, maybe if cert was granted, the SG would have confessed error again. We don't know. But one of the things that the SG did say was that, don't grant cert, not just because the commission is going to fix this, but also because it's just not practically important. And I just wanted to say before stopping that, I just don't think that's been borne out, because if you look, it's been over 100 11th Circuit decisions that cite Bryan, over 100 district court decisions in Florida alone that cite Bryan. And that's not to say that all of those people would have gotten relief, but it is to say that a lot of people were prevented from having district court judges look at far and wide at the facts and circumstances of their case to give them a second look. And it is troubling when only the defendants in the 11th Circuit are constrained in that way. So it is unfortunate that the Supreme Court denied cert, and hopefully the commission comes along and fixes that pretty soon.
Yeah, I know that's a priority for, I think, both the federal defenders and the Department of Justice to get some clarity on that from the commission whenever they're constituted. So lastly, Judge Williams and Andy provided a nice segue by talking about the number of motions that cite Bryan. You know better than anyone on this panel the sheer breadth of requests that you received from inmates under the First Step Act. Can you tell us your experiences, either positive or negative, in dealing with compassionate release issues over the last couple of years?
Sure. Let me first start by saying this morning, the commission released their report on the impact of the First Step Act and the COVID-19 pandemic. And so I think that is an important study that all criminal practitioners are going to have to look at. It confines its analysis to 2020. And of course, there will be argument about the viability of the data points. Are they under-inclusive or over-inclusive? But looking at 2020, it says that 96% of those petitions filed by defendants were granted in 2020. And I was startled by that statistic, especially now when we have Bryan, which is going to govern how we move forward. The study also showed that in 2020, again, 96% of the petitions where relief was granted, it came from defendants. Only 1% came from BOP. And the one thing everyone can agree on, I think, is that BOP jails everywhere were not designed to handle pandemic. I mean, that is not a criticism. That's just a fact. And so The First Step Act, many people, I believe, thought would assist in what was happening during COVID, because one couldn't rely on an overwhelmed, understaffed prison system to get to the, as Michael points out, many cases that came to us as judges. Finally, in terms of the analysis, it seems that nationally the granting in 2020 was 25.7%. The 11th Circuit was 19.5. The only circuit lower was the 5th Circuit at 13.7. The Southern District, though, had a 29.7% grant rate, which was at or consistent with the national average. So I haven't had time to really read the report. I just saw it this morning, but I wanted to bring that to everyone's attention and say, in answer to your question, Michael, the positive experience was having this area of our justice system brought to light, as I think the dean pointed out. And that was the negative, the overwhelming volume. But I think most of my colleagues, I don't think I'm telling tales out of school. Most of my colleagues understood that in an analysis under First Step Act, it wasn't a floodgate situation, which sometimes is used to describe the possibilities if there is relief granted, but it was a deliberative, measured process that had the guideline commentary to assist. But now Brian says that governs, and so we'll have to forge a different path.
And maybe be ready for a new set of motions if the commission remedies 1B 1.3. Thank you, Judge. The last case we're going to discuss is another en banc case, United States versus Brown. In Brown, the en banc court vacated her conviction by holding that the district court abused its discretion by dismissing a juror who said that the Holy Spirit told him that the defendant was not guilty, but then assured the court that he was following the instructions and basing his decisions on the evidence at trial. Because there was a substantial possibility that he was basing his decision on the evidence in the law, removing the juror violated the defendant's Sixth Amendment right to a unanimous jury, according to the majority. Judge Newsom, joined by Judge Grant, concurred, emphasizing that the juror's Holy Spirit statement had to be viewed in the context of the record and that this case wasn't really about religion. Judge Wilson, joined by Judges Martin, Jordan, and Rosenbaum, Judge Jill Pryor was recused, dissented, emphasizing that the appellate court should not second-guess the district court's factual findings about the juror, which should be reviewed deferentially. Judge Rosenbaum, joined by Judges Wilson and Martin, separately dissented, emphasizing that the majority's reasoning would equally prevent and thus deter a judge from dismissing a juror who said that the Holy Spirit had told him to convict the defendant. Again, I'll start with Dean Lawson. Dean, in this case, the lineup of judges seems flipped. The judges who are ordinarily viewed as progressive argue that a conviction should be affirmed, while the judges who are ordinarily viewed as conservative voted to vacate the convictions. Does that lineup tell us anything about the issue at stake? Is this case really about evidence and fact-finding, or is this case about religion?
Thank you for that question. I think this case is about religion. And I think this case is about how or if a juror who actively practices their religion can serve on a jury. What does that look like? And what words and things can they say or do? And that's why we might see some movement in how the judges see this particular case. But I think what's more interesting, even beyond that, is that this case raises a lot of questions about juror deliberations and how they're conducted and how things that happen in jury deliberations are revealed to the court. And we've seen that in other cases where it was not religion, it was other biases that were revealed, and how the district court is to deal with those issues. So religion, race, other issues that come up in deliberations, and how courts should deal with those statements, and whether it impacts the ability of the case to be fair, notwithstanding those statements.
Thank you, Dean. And that's your last comments is a nice segue to this next question to Judge Williams. You know, in thinking about the issue in this case, of course, the issue arose because other jurors communicated this issue to the presiding judge. And as Dean Lawson alluded to, that's not always the case, because we recently see in the Ghislaine Maxwell case in New York, there was a jury deliberation issue, but that only arose post-verdict when one of the jurors gave an interview saying that he was a victim of sexual abuse himself, and he talked about his experiences in the jury room while they were deliberating, despite answering no to a question whether he was such a victim in the questionnaire. So to me, that highlights that dealing with jury deliberation issues is one of the more fraught issues that district court judges have to address. Judge Wilson, in his dissent, likened it to walking a tightrope. Can you discuss with us what you believe to be the appropriate role of the trial judge in resolving these type of issues?
Well, I think the most important factor is first transparency. You know, you have a jury deliberating and you've told the jury that time and again that they can't talk about this case with anyone. But they, of course, can speak to court personnel about where do I get my parking stamped, or how long are we going to go today? But sometimes,
or you can order us dinner, right?
Are we going to get dinner, or are we going to let us go home? And usually that's not anything I will summon all the lawyers back into the courtroom to discuss. But if a juror sends out a note, as perhaps this juror did, or a juror asks a question of court staff or a CSO that goes to a substantive matter, when is the defendant going to testify? Then everybody comes back, and the discussion is had with both parties as to what, if anything, they want the court to do, because I agree, and I think all of the judges in this decision agree that the approach must be sensitive and modest in making inquiry if need be, so that you do not invade the deliberative process. And I think that that is true. And I think that Judge Wilson, though, is correct in that that really should be left to the discretion of the trial judge, who is having to handle this as it happens in real time. I think trial judges are aware of the issues, the potential problems, and the need to be sensitive to addressing an issue with a juror, but not inserting itself or any additional dimension to the juror deliberation. The one thing I would, I don't know if other people saw this in the decision, but that I took away is, at least that the majority is advocating that judges, and I would concur with this, be engaged in training on, discussion in cultural competency, because the majority makes a point of saying that judges aren't necessarily aware of how ordinary people live their lives and vernacular used. And I think that is a clarion call to having judges trained in every area of a community and a juror's life, so that when these issues arise, we are capable of addressing them in the appropriate way.
No, I think that that's a great point, and thank you for adding that. Andy, I'll ask you the next question. In his dissent, Judge Wilson writes that the majority implicitly overruled a prior case's deferential standard of review with quote unquote something more closely resembling de novo review. Do you agree with that's what the majority did?
Yeah, I do, because so there's a prior decision called Abell, which held that when the trial judge finds that there's no substantial possibility that a juror is deliberating properly, that's a finding of fact that is reviewed for clear error. And in this case, what the majority did is it references the clear error standard in its standard review section, and it references the standard once or twice in the analysis, but that's not how the analysis is framed. Instead, what the majority appears to be doing is reviewing the record for itself and to decide for itself if there's any substantial possibility that the juror was deliberating properly. And unless the record is unambiguous that the juror was behaving inappropriately, then the majority holds that it's an abuse of discretion for the trial judge to dismiss that juror. And it's hard to see where the deference comes into that analysis. And, typically, we see this all the time, clear error review. The hallmark of that is if there's evidence going either way, or there's arguments going either way, the Court of Appeals is not going to second guess the trial judge's factual determination. And we come up all the time and say, well, look, the evidence was more in our favor. That witness was less credible than this witness. And the Court of Appeals says, well, maybe we would agree with you if we were the trial judge, but we're not, so we have to defer. And it's just that's not happening here in this decision. And it's not really clear to me why. There's a point at which the majority says, well, there's no credibility determinations in this case. It's undisputed what the juror said. The trial judge said that the juror was being sincere. But the trial judge expressly said that he was making a credibility determination. He also said that the juror was being evasive at times about his answers. And at the end of the day, the juror, in my mind, is making conflicting statements here. On the one hand, he's saying the Holy Spirit told me to acquit. And then the other hand, he's saying, well, I'm deliberating according to the evidence and the law. And it's hard to reconcile those statements. And what I think the majority is doing is trying to reconcile them for itself and saying, well, here's what the juror really meant, that the Holy Spirit is giving him guidance about how to analyze the evidence and the testimony, which everybody agrees would be proper. The problem is the trial judge considered that and rejected that and said, I don't think that's what this juror is doing. And so it seems to me a classic case for where clear error review would come in and, defer to the trial judge. So, it's unclear to me how this is going to play out going forward. If this, because the majority does not formally overrule the clear error standard, purports to apply it. So it's unclear if this is just a one-off based on the facts, or if this is sort of a sea change in how we're going to review these issues going forward.
Right. Maybe it'll be the Bush v. Gore of jury deliberation issues. So your answer, it provides nice context to the next question I'll pose to Emily, but give you time to respond if you want to, Andy. As seasoned appellate lawyers, do you often see the Court of Appeals, quote unquote, overrule a district court's factual findings that were based upon the judge's ability to hear live testimony and observe tone, inflection, and demeanor? He asks in a loaded way. Emily?
No, and I don't really favor it. Honestly, I think it seems to me there's a little subtext going on in this opinion, which is, very obvious. But to change the standard and take away, the one jury questions, I think issues with juries are probably the hardest thing, and to take away the district judge's sort of impression of the situation on the ground, I don't understand what was, I do understand, but it seems not prudent and maybe not the best course to have appellate judges looking at a cold record, sort of discounting the fact finding by the district judge and saying, in effect, we would have reached a different result. And in a variety of contexts, that would not, in terms of witness credibility and other matters, I think the district court is really in the best position to take a look at what's going on and make those determinations, and should be given deference. So this is an interesting opinion. And I, like Andy, when I read it, thought, well, they say they're applying clear error, but this is totally not clear error. And it's hard to know what's going on and how much application this will have outside this very narrow context. I mean, it's a pretty unique situation, and maybe it will stay where it is.
So since I think, because Emily agreed with you, Andy, I'll move on to the next question and waive your rebuttal. So the next question, and I'll also include Dean Lawson in this question. In her dissent, Judge Rosenbaum asserts that the court is unanimous that the rule announced here would apply to a juror who says the Holy Spirit told him the defendant is guilty, and the judge would be powerless to dismiss that juror. Do you agree that the rule is the same based on this case? And would you say, if it is the same, is that a good thing?
Okay, I guess we'll go first. Okay, so I agree that the dissent says that the court is unanimous on this, and there is no response or denial from the majority. And this came up during the oral argument, and the lawyer for the defendant, who happened to be Paul Clement of all people, agreed that this rule would be the same. However, I mean, I think if I was representing a client who was faced with a juror like that, I would be arguing that the standard should be different. Because, I mean, if you just look at the text of the rule, there's a rule here, and the standard is good cause. And I would revert back to that, because it seems to me that the reason why this no substantial possibility standard has come into play is because of the Sixth Amendment concerns about the right to unanimous jury verdict. And so we really apply a heightened standard to avoid dismissing jurors who may simply be unpersuaded by the government's case. But when the juror comes in and says, well, I'm inclined to convict because Satan told me to, well, I think the Sixth Amendment considerations cut in the exact opposite direction. And we want to have a more lenient standard so that the trial judges can remove those people, because that is in accordance with the Sixth Amendment. And so I think I would argue, if I had a case like this, that we should just go back to the text of the rule, and the Sixth Amendment doesn't require any heightened showing in that situation. But Paul Clement disagreed with that, or didn't make that argument. So maybe I'm missing something here.
Although he didn't have that case, so perhaps he was making a strategic decision on behalf of his client. Emily, and then Dean Lawson, and if you want to respond or add.
I sort of like Andy's argument. I think arguably it could apply in that scenario, and that is probably not. There are all sorts of situations where it could apply that it might not be optimal. I mean, I think Paul Clement was pretty convincing as to this point. But we would have to see what Andy's creative argument, how it would play out in the Court of Appeals with a different scenario.
Thank you. Dean, I mean, are there good reasons why the rules shouldn't be the same, like Andy has argued?
Well, I pretty much agree with Andy, and I think the consequences and the stakes are different when we look at the belief is for the conviction, and it's not predicated on proof of the material elements of the charge. So that would be a different analysis, I think, entirely, if we had the right case to tee up those facts. And I also wanted to just add to Judge Williams' point about cultural competency, that the ABA is now urging law schools to include in their required curriculum teaching on cultural competency. So the next round of judges that will have had that in their foundational law school training will be building on that as the courts include training on the bench.
Oh, that's great. That's great to know. That's that's very helpful. We're at the end, but I will add that that Judge Williams chairs the court's Diversity and Fairness Committee, and there's a small group of lawyers who interact with the courts committee. And this last fall, we put on a cultural competency seminar or talk to sort of, let more experienced lawyers know that these are issues out there that we all have to work on. But it's great that law schools are now adding that to their curriculum. So thank you. So I think we're at the end of our hour. I want to thank our panelists. I think practicing in the 11th Circuit, there's never a shortage of interesting cases to talk about, and I really thought that all your comments were insightful. So I want to thank you. I also want to thank the American Constitution Society for hosting this panel, and be on the lookout in your email inbox from emails from the ACS. They have a variety of panels that are well worth your time. So thank you all for attending, and see you soon.
Thanks.
Bye.
Bye.
Thanks, everybody. I think that was good. And according to Emily's clock, it's still noon. So
Still there.
time
Guys,
literally
thank you for
stood
having
still.
me.
No, thank you for joining us. I thought it went really well.
It was
Kind of-
very disconcerting what Andy said. There was like Michael Caruso all over my computer, and I'm thinking,
Yes.
okay,
Oh
well,
my God, I have to
all
get
Mike
rid of this.
Caruso all the time. That works.
I don't know why, like the ACS set this up, so I have no idea.
You know what?
Popping
I-
up.
You're replicating.
I
There's
think
81
what
of
happened-
you.
Like the Matrix.
I think when you forwarded your email to everyone, I think it had like a link particular to you or something. That must be what it is.
Oh, so yeah, definitely my fault then. Yeah, because we had those separate logins. Okay, my fault. So
No, world domination. Go for it.
Yeah, it didn't make me feel too nervous at all to see all Michael Caruso's. That was great.
I mean, even one shouldn't make you nervous,
Thank
really.
you for
But
being nice to me. It
We're
was
still recording.
okay.
Right.
We're hanging up.
No,
Right,
I'm
but
not
thanks.
saying we have to hang up. I'm just pointing that out. And I didn't say Pena Rodriguez, but I kept thinking, that case in the back of my mind as we're talking about these juror cases where the court was so clear that race is different. And all the amici were arguing, all the various biases, which we do see in these cases.
yeah, I mean, I'm glad you brought up that point about cultural competence training, because it is, we do live in bubbles now, either, where we were born, where we're raised, where we go to school, and, can only help by being exposed to all that information about other people. So it's good that it's being taught now.
Well, I'll send you all the updated ABA rules that just came out recently about it.
Oh, great. I'd
Great.
appreciate that. Thanks.
Thank you.
Bye, everybody.
Bye, guys. Bye, Andy.
Bye,
Nice to
guys.
see you.
Yeah.